My Lord Swami. My Lords, may I be allowed to mention an criminal appeal, my Lord, for listing for tomorrow, my Lord, if possible, my Lord.
Or division
DV matter. My Lord, this matter was taken up on Monday. There was a confusion regarding the condonation IA regarding the days. So actually, my Lord, the delay as it was given in the court copy, it's correct, my Lord. But inadvertently, the same has not been reflected in the PP copy.
that was not fun on the side, I think. In their copy, it was 395 or something like
That's
that.
why you're
I
right.
can remember.
Yeah, that's why you're right. That inadvertently that correction has been done. It's the days that is reflected in the code copy is the correct one, Lordship. There is no requirement of modification in the code copy, Lordship. It is the days.
But why you have furnished the, I mean, the incorrect, I mean, this is a copy which we have furnished.
Yes,
The
Lordship.
days are being 345 or something
Actually,
like that.
Lordship, when it was filed, the 60 days that is taken for limitation, that was not there. So we had to make that adjustment. That's why the question.
Tomorrow, but tomorrow, it's not there. Monday. Lecture for Monday?
Lordship,
Because tomorrow, only for one matter, DB may not be there. So for Monday,
Friday, Lordship, Friday also.
Friday, matters are there. Friday, for everybody. Because every day division will be different with that.
But if
Because if 1-2 matters, then may be difficult for DB. Monday. Let it be on Monday or what is?
much of it.
May I please, Lordship? Lordships, this present file is filed. Fact of the case is that the Ministry of Health and Family Welfare, Government of India, sanctioned sum of rupees 14 crore for establishment of state drugs regulatory mechanism and setting up of drug laboratory in the state of Arunachal Pradesh. And initially, fund was released for financial year 18 to 19, sum of rupees 6 crore was released. And that 6 crore was divided to 7 districts, namely Papumpare. Papumpare was allotted fund of rupees 3 crore 27 lakhs 32,000, and West Coming district was allotted 30 lakhs. North 73 30 lakhs, West Siang 30 lakhs, East Siang 30 lakhs, Lohit district 30 lakhs, Tirap district 30 lakhs for this project only, my lord. So what happened after allocation of this fund? None of the district has constructed any infrastructure of this project, except the Bomdila, West Coming district has only constructed one small building, which is unused still till now. So, Lordship, the petitioner, after knowing this, petitioner has filed RTI before the concerned authorities. Department Director Health Service Naharlagan, he has filed RTI and he has received documents. The RTI includes, Lordship, and come to page number 27, Annexure A series. This RTI reply being furnished by the concerned authorities, Director Health Service. Accordingly, he came to know that the executing department was given to Hydropower Corporation Development of Arunachal Pradesh Limited for executing this project, my lord. So after knowing this, the petitioner was again seeking RTI before the Hydropower Development Corporations. And they have replied, given their reply, Lordship. Page number, my lord, may come to page number 97, Lordship. Annexure E. Page number 97 in my petition, my lord. So Hydropower Development Corporation has flatly denied that they have never received fund from the Director Health Service, and they have no any such records that they have executed such project in the state of Arunachal Pradesh. So, my lord, now it's come to know that this fund was completely misused, that 6 crore was completely misused, and thereafter the central government has again sanctioned financial year.
This is for which district? This the RTI 97.
Yes,
That's for
RTI is, Lordship, seeking for.
no, it's okay. Seeking for
Yes.
for
For
in
entire
all districts, these things are happening.
All the projects, yes.
All the projects.
All the projects. So they are denied that they have never been received PAN from the Director Health Service, Government of Arunachal Pradesh. And they have also denied that they have no any such records, that they have implementing this project. So, my lord, again, Government of India has Ministry of Health and Family Welfare sanctioned rupees 2 crore 12 lakhs and rupees 1 crore 88 lakhs for financial year 21 and 22. And another rupees 4 crore sanctioned for financial year 2022 to 23. So this is when petitioner has seeking for this utilization of the schemes, this sanction, but they failed to furnish any documents. And they are now stating that they have no any such records. So, Lordship, this project is for greater interest of the states, and this project is very vital one in the state of Arunachal Pradesh, which is very important for the state of Arunachal Pradesh. As Lordship may come to page number 30, project detail report, my lord, with here, which proposal being sent by the Director Health Service, Government of Arunachal Pradesh to Ministry of Health and Family Welfare. Page number 33 is a synopsis of the action plan, my lord. Action plan, how to implement this project. May I read out the action plan, my lord? Page number 33 is the synopsis being annexed in the DFR, my lord. May I read out, Lordship? Under initiative of the Government of India, Reform-related Standing Parliament Committee for Health and Family Welfare, Government of India, meeting was held on 22nd to 27 October 2010 at Tawang, Arunachal Pradesh. In the said meeting, various critical gaps, problems in the functioning of the drugs control mechanism in the state was highlighted before the committee. Further, meeting for the state health minister secretary was convinced under the chairmanship of Honorable Minister for Health and Family Welfare, Government of India in the Hyderabad on 12 and 13 January 2021. Subsequently, on DO letter number so-and-so dated 11 February 2011, from the Secretary Health and Family Welfare Government of India for preparing action plan for strengthening of drugs control mechanism in the state, drug testing laboratories and DO letter number so-and-so dated 8 August 2012 from the Director Health and Family Welfare Government of India requesting to submit year-wise PAN requirement for studying of two components are being received wise state drugs regulatory mechanism, established state drugs testing laboratory. My lord, and then Lordship, this project is for 5 years plan, my lord. 5-year plan, 2012 to 17. But PAN was received on 18-19, Lordship, 2018 and 19. And my lord, the objective of the PAN, is mentioned, Lordship, in page number 35. Lordship may come to objective, para number 2, my lord, page number 35. The main objective of the action plan is to strengthen state drugs regulatory mechanism and to set up state drugs testing laboratory to achieve the goals with retroactive implementation of Drugs and Cosmetic Act rules.
Okay, but
And-
as per you, the work is it's
Yes.
not in progress and work
Yes,
is not
my lord.
implemented.
And my lord, the surprise, very interesting thing is that already sanction order is clearly mentioned by the Government of India in sanction order number, my lord. Para number 12 is clearly mentioned that work should be, proper tender should be implemented. Tender should be plowed. But concerned authorities has never been plowed any tender. But work was accommodated to the private respondent number 15, my lord. Work was aborted without any tender. So amount was being paid without executing of work, with implementing of this drug testing laboratory in 7 districts, my lord. Except Bomdila, they have constructed one small building, my lord. So PAN is
How this petitioner number, respondent number 15 got the project?
respondent number 15 is the contractor, my lord,
Yes, I know.
who has received money without executing any work. Sum of rupees 6 crore as initially sanction being given by the Government of India, Ministry of Health, that was paid to the private respondent number 15, my lord, who is a private contractor in the instant matter, ma'am.
Yes,
My lord, for today, notice may be issued, my lord.
issuing notice.
Otherwise, from the sanction order, I find that there is no sanction for construction of that building. It was only 6 crores was only for strengthening of drug testing and drugs regulatory system, not the,
For establishment and agency.
not establishment.
Also, PAN was given
Strengthening
for
of,
infrastructure. Also.
drugs, that infrastructure sanction is not there, page 76. although the project report was for strengthening of drug regulatory system as well as the
Anyway.
Anyway,
We are
that-
checking. Mr. And options of the petition. Also heard Mr. Anderson. Your representing respondent.
one and my lord 13.
1 and 13.
Yes, my lord.
1 and 13.
Mr. Tagum
Chairman.
will be
Managing.
for 2 to
Tagum is for 2
to 12.
to 12.
Yes, the
Yes, and I put them respondent number 14, madam.
40. Location number. It's yeah. Investigation of the 226 of the Constitution against the misappropriation of public money, which meant for being sanctioned for establishment of state drugs regulatory mechanism and setting up of drug testing laboratory in Arunachal Pradesh for a tune of rupees 14 crores by the respondent. Issue notice. for review.
My lord, I have a prayer, my lord. My lord, till returnable date or return of notice, lordship payment should not be made, if any, if workers awarded to the private respondents.
Let us see first, why not?
Otherwise, completely
Private
it's misuse
respondent,
of the
you have
fund. my lord.
submitted it for the
no,
private
my lord.
respondent.
First of all, we'll have to understand what the
Yes.
PIL is all about, my lord. Directly stalling the payment of someone who is executing a work, that also would not be good, my lord.
Because there is a state drugs regulatory mechanism
Yes, ma'am.
as well as the setting up of a drug testing laboratory.
Yes,
So
yes, ma'am.
for what,
So, for what
purpose it was released or
Yes.
when that has to be said
Yes.
without going, issue notice corridor, returnable within 4 weeks. No formal notices referred to the census. It takes steps. We are listing it after 4 weeks, otherwise it will be.
Yes.
Listing list after 4 weeks. After 4 weeks, let them file their affidavit in
Yes,
official records. Then there may be some interim,
ma'am.
otherwise.
Highly obliged. ma'am.
Your lordship, it's a jail appeal. However, your lordship, there is a delay in preferring the appeal. So your lordship, we will settle that even if it is jail appeal, there's some explanation has to be given. May not be separately, but
What is the delay? Whether delay has been here calculated?
delay is your lordship 173 days, your lordship.
173 days.
Yes, your lordship. The
In
the
which
limitation
way-
period
in
is 6.
where it is delay is calculated.
Your lordship, that has not been, that is not there, your lordship. That is my humble submission, that at least that explanation has to be given even in jail appeal, so that the court can pass an order by condoning the delay. Maybe on the main this.
From you after calculating.
Yes,
got
yes, yes. I have
173
calculated, your lordship, and according to me, it's 173 days delay, your lordship, in preparing this,
173 days.
your lordship. So it has to be filed through your lordship, legal aid council, your lordship. It's a jail appeal.
Yes, okay.
Because no explanation in the memo of appeal also, your lordship. It's just an application, not also a memo of appeal.
Memo of appeal is prepared by whom?
By the registry, your lordship. But your
By the registry only.
legal, actually, your lordship, it should be through legal aid council.
Council is there, I think.
Yes, your lordship. The panel of legal aid council is there, but no one has been appointed, entrusted yet, your lordship. At this stage, your lordship may direct the registry to appoint a legal aid council and accordingly file appropriate application, your lordship.
Mr. He attended an additional duty on behalf of state, and on behalf of state respondent. This is an jail appeal filed through the registry of this office. However, it is seen that till now, no legal, the legal aid council has been appointed. More so the, Mr. Ete submitted that, though there is no separate prayer or mention in the memo of appeal, but it is seen that there is 173 delay in filing the post expera. Registry is accordingly directed to file, directed to appoint one legal aid counsel for the appellant and also to separate forwarding. Register. Register, we appoint, that is there. Who will calculate the fees? And accordingly, the legal aid counsel may be directed to file the petition for condonation of delay, if any. List accordingly after 3 weeks will do.
Yes, Your
After
Lordship.
3 weeks.
And Your Lordship, here also, Your Lordship, 386-day delay.
Here also,
Yes, Your Lordship.
386.
Yes, Your Lordship.
Why registry? Registry, we have not seen it. It is the duty of the registry also to see whether.
Yes, Your Lordship. That has to be actually in averment made should be made in the application also, Your Lordship. That will suffice actually, but no such averment has been made here, Your Lordship.
No such averment is there. Same order. Registry is directed to. Automatically, definitely jail appeal we generally condone the delay. There's
Yes,
no-
Your Lordship.
But the question is there has to be.
One formal, Your Lordship, explanation must be there, Your Lordship. Yes, yes. Your Lordship, here we are directed to file a verification report from the concerned PS, Your Lordship, which is yet to receive from the concerned PS, Your Lordship. Your Lordship may kindly grant us further 2 weeks' time, Your Lordship, so that we can produce the verification report, Your Lordship, verifying the address of the victim, Your Lordship. Respondent number 2.
This is respondent number 3.
Yes, 2.
And who is respondent number 2?
Your Lordship, here is mother, Your Lordship. It's a 30. In the light of the existing matter, Your Lordship, the notice has issued to the victim family. This is victim family, mother. So the court was of the view that the verification, since the address was not traceable, so the concerned PS was directed to verify the address and file the report.
Generally, 302 are like 376 for POXO.
Your Lordship, yes.
On a separate footing, but 302 is.
Your Lordship, the Deepak Nayak matter was squarely covered the sexual offences. But Your Lordship, Jagdish Singh matter is a general law which has been later on reiterated by the coordinate bench of this court also, wherein Your Lordship.
Now, just tell us whether the service report is returned for the respondent number 3 or not yet returned.
Not yet returned, Your Lordship. Further 2 weeks, Your Lordship, last chance may be granted, Your.
One is not here. Let's represent the appellant. But Mr. It demanded additional briefing appearing for the state respondent, and it is submitted that as per order dated 25/9/2024. It was directed to produce the verification report regarding the address of the respondent number 3. But inadvertently that will not be collected and sought for 2 weeks you need?
Yes, 2 weeks.
2 weeks time for the verification of the address of the respondent number 3 as directed by this court by the order dated 25/9/2020. List accordingly after 3 weeks.
Deeply obliged, Your Lordship.
So we have taken steps,
Yes, Your Lordship.
9 to 11.
Yes, I have taken the steps upon respondent, private respondent.
It's note of registry on 5/11/2023.
My lord,
Yes,
I'm appearing on behalf of respondent number 10.
only 10.
Only 10. My fault that we have to, I mean, given some time to find the proper number.
So you are appearing.
My lord, 2, 5, 6, 7, and 8, my lord. I'm also praying some time, my lord, to file a claim, my lord. I'm yet to receive instruction from the council report.
Your Lordship, I'm for respondent number 3 and 4, Your Lordship. I need some more time for filing counter affidavit, Your Lordship.
You're Miss Handy.
Yes, Your Lordship.
Well, the name of the respondent number 1 may be strike off. There is no matter to whisper against the respondent number,
And not the necessary part.
not necessary. All has been done by the other
Yes,
respondent.
yes, what do you want to say? You just think over it, but he is saying that he is not the necessary party, actually, it's state, I mean, image. So number 1 maybe strike out, or if you think that it is necessary party, we don't have anything to say, see. Okay, on the next date, you will just tell us if it can be. But MS and Handy Tilanet counsel for the petition. And also heard Mr. M. Pato Tilanet DS GI for the respondent number 1, comma MSP Pandu Tilanet State Council for the Lanet's government advocate for the respondent number 3 and 4. And Mr. Al Parmin, the standing counsel of Power Department representing the respondent number 2, 5, 6, 7, and 8. And Mr. Suki and Suki, this Suki is appearing on behalf of the respondent number 10. It is submitted by the Lanet Council for the respondents. They need some more time to file their affidavit in opposition. However, Mr. M. Kato Lanet DSGI submitted that respondent number 1 is not necessary party in this case, and name of the respondent number 1 may be strike out. Service report is still awaited for respondent number 9 and 11. The service be awaited for respondent number 9 and 11. 10 is already in there. It's no matter how many weeks you need, 3 weeks or
This is members again.
Yes.
This is 4 weeks now.
4 weeks. List up to 4 weeks, and I bring the respondents to file their affidavit.
Yes, Your Lordship.
Please, madam.
Yes.
Well, I have corrected the course title, madam. There is a delay of 31 days in filing the connected writ appeal, my lord.
Connected
Writ appeal, my lord, is filed. My lord, I have explained the delay
in
in paragraph 2, my lord.
paragraph. Yes, what do you say? 32 days, no?
31 days.
31 days. Can be condoned?
Pardon, my lord. My lord,
Can be condoned or want to say anything?
but, yes, there is a private respondent in this case, my lord. I am put official respondent 2 and 4, my lord. This is, my lord, let notice may be go, my lord. To my respectful submission, my lord, it should not have made an objection for only 31 days, my lord. I am also their employee, my lord.
So who is the private respondent? Number 5?
5
5?
to 24.
5 to 20. So these are all private respondents.
Yes.
Then notice has to go.
No, I am appearing.
Oh, you are appealing for 5 to 24. Oh, it's okay then now.
Entirely two lords.
Huh?
I have no objection.
You know. Yes, Mr. Conway.
But, then
The respondent has to obtain.
I also, my lord, leave up to the, my lord assembly.
So your permit is appearing for four.
I am for my lord, 2 and 4, my lord.
2 and 4. Mr. Pami is for 2 and 4. Why, you are appearing for 1. Yes. So yeah, 1 and 3, I think.
For 3 you looks like
You are appearing for 1 and 3.
only 1 you look. See, for
Only
3 I
one.
have to see.
3 also, my lord, he will be appearing
3
because
you can appear. I think.
chairman is the chief secretary, my lord.
You have to take instructions.
Yes.
Otherwise, you are appearing for only 1.
Yes.
He appears for 2 also, Komal appears for 2 in the.
Yes, you can appear for 2 also, I think. 1 and 2 corridor. Number 1 and 2.
Who is the commissioner power? So he will be appearing for 2.
Then Mr. Pami can appear here.
4, my lord, I am for 2 and 4, my lord. 3, my lord.
No, you are appearing for 2 and 4.
2 and 4.
Yes, he is appearing for 2 and 4. It's a commissioner power. 2 and 4. Mr. Yeram is appearing for 1. 3, you are not going to appear.
3 he can appear.
He can-
But I'm.
You can appear for 3.
Before the writ proceedings, Komal appear.
In 1 and 3 you.
1 and 3. And you are appearing for 5 to 9, 5 to 23. 5 to 23. 23 or 24? 24. Huh?
24.
We are having 23. In your petition, 24. Oh, sorry, 24. Yes, 24. This is an application. 31 days to get 31. Application under section 5 of the limitation. Containing for condoning the delay of 31 days in the connected with appeal. Connected with appeal. Against the order, judgment and order dated 31/08/2024, passed in WPC 149 of 2023. It is submitted by Mr. Saikya, Land Council for the petition, that that due to I element of the appellant, he could not file the writ petition within the stipulated period of time, as he was advised by the doctor to take rest for 6 weeks. 6 weeks, and the applicant was not and was not 6 weeks after his operation in the eye operation. The entire round of delay has been mentioned in para number 2 of the said petition. The learned counsel representing the respondents raised no objection. Submitted that they do not have any objection if the delay is confirmed. But considering this submission made by the learned counsel for both sides, and also considering the ground mentioned in the para number 2, which is found to be justified, which is found to be reasonable ground. Accordingly, the prayer for condoning delay of 31 days in preferring the connected writ appeal is hereby, and accordingly the delay of 31 days is condoned in preferring the writ appeal connected so with above observation, the present petition interlocutory application is allowed. The registry will accordingly register number connected writ appeal filed by the petition, and will list accordingly.
And may I pray with madam, the main writ appeal may be listed on Monday, madam,
Monday.
on next Monday.
May not be possible.
Then witness, the next witness, you know.
Wednesday not at all possible.
Wednesday will be difficult, I will be in Guwahati because actually there are similar.
Difficult on my part also Wednesday.
Monday, then Monday, if
Monday.
time permits, Monday.
Okay.
Always.
Then I'm appearing on behalf of MK Sharma.
Huh?
I'm appearing on behalf of MK Sharma.
Ah.
This matter may be fixed for admission hearing.
You are appealing for MP Sharma.
Yes, Your Honor. This matter may be fixed for admission hearing.
It's
Up to
already
2
fixed for
weeks.
supplementary hearing.
Supplementary hearing matter.
Not required for.
Paper book is ready.
Everything is done is for
There's
final
no
disposal.
need for any admission hearing. It's already admitted. Paper book is ready and is final hearing for supplementary hearing.
The MK Sharma is not present here right now, Your Honor. So this matter may be fixed after 2 weeks.
MP Sharma is
It's
not
not
available.
in the,
today.
not in the station, Your Honor. MK Sharma is not in the station, Your Honor. So this matter may be fixed after 2 weeks.
And he is not present today.
Not present today, Your Honor.
Acha.
Going for adjournment.
You are Mr.
H. Thai.
नाम को लिख रहे हो hard Mr. Swenson. Counsel appearing on behalf of Mr. M.K. Sharma, who is submitted that he is out of station and not in a position to argue the matter and accordingly paid for an adjournment. To which the state respondent is more objection. It's a case of
Pokso, Your Lordship.
Pokso.
Pokso, yes. The victim is also appearing, Your Lordship.
Yes.
Yes.
Lordship, for the first time I'm appearing, Lordship,
For the first
after receiving paper book. After
time.
receiving
Why
paper,
for the first time? Because it is in supplementary hearing.
this way, Lordship, matter would have been fixed for order, Lordship, but because this is first appearance.
You are Mr. G. Ginny for the informant. You are
Victim, Lordship.
victim or informant?
Victim, Lordship.
Victim is
Ah.
party here.
Yes, Your Lordship.
Respondent number
Pokso
2.
matter, Your Lordship.
No, POXO is okay,
Yes, sir.
whether victim through
But
victim or through
victim,
informant.
through victim only, the victim, notice was served to the victim, Your Lordship.
For the victim. Okay, really. So you want it to be after 2 weeks,
Yes, Your Honor.
but one eye is also.
Yes, Lordship. I also
Suspension for
Suspension.
sentence, yes, sir.
They're not pressing for suspension, we hear the matter finally.
Yes, sir. Yes.
Otherwise also it is a POXO matter, POXO 6 or 4,
Sorry.
POXO 6 or 4,
Yeah.
POXO 6 or 4 it is,
Pokso, Your Lordship, 6, Your Lordship.
6,
Yes, 6 men punishment. Lordship,
it's chapter 2.
4 under section 4 of Pokso Act, Your Lordship.
Now it is a supplementary hearing list.
It's better for final disposal, Your Lordship,
Yes,
altogether.
better.
Yes.
Yes, 16 and 17.
I'm appearing for a private respondent. I'm filing my affidavit today, ma'am. So it may be taken up some other
The
day.
matters are connected matters or what?
It's not connected, they are tender matters, similar matters.
Similar matters.
Yes.
So in both the matters, you are also appearing?
Yes,
For the-
petitioner.
I'm for the petitioner.
In both the matters.
Yes.
So you are appearing for the private respondent.
Can it be, if Lordship, can the Lordship take it up on Monday, if Lordship?
Monday may not be possible. Lots of matters are is already
Can it be on the 18th level?
18th can be 18 more or less. 18.
Next Monday.
Next Monday will be able to?
Next one,
No, yes.
will be filing
Be
at
able to
affidavit.
filing your,
Today.
oh, you're today. You're fine.
It may be fixed on 18th. Obliged.
With the consent of the addressor, demanded counsel for the private respondent, Mr. D. Pangin, later a order paid some more time to file, no, submitted that he has already, he will be filing the counter affidavit will be filing for the private respondents. According
My
to
lord,
for an adjournment.
by tomorrow, because
By tomorrow.
I have to Because the
So
paging
it's
initial is done
almost-
after.
It's ready and will be going to file shortly within this week. Prayer of the matter, both the matters fixed. Separate order you pass because both the matters are not connected. So in both the matters, we are fixing it on 18th.
Yes. Okay.
Lordship, I beg to mention item number 15. I am for the private respondent number 5. So we need some time to file affidavits. So item may be released after 2 weeks.
On the date was same date, but still, and for the petition.
Here also you are appealing for.
Yes, same, similar matter, ma'am. All are tender matters.
You also appealing same
Yes.
And for the state.
state, yes.
I have already filed
Parties
my.
are same, the private responsibility different.
In 16 and 17, okay, whatever.
Yes.
The Panging is appearing and here you are appearing for the private respondent.
Yes, private rest. Item
Second
number
order,
15.
Mr. Tarak and they are also appearing. You see the list? And okay, we'll reflect your name.
Okay.
Otherwise, these are in order column. Why it is in order?
Mother, this tender matters, so this honorable court definitely wanted to, otherwise it will become infructuous, mother. If this take late, it becomes late, mother. If they delay.
No, I'm not on that. These are all in orders column.
Yes.
Why?
They wanted to file affidavit, that's why.
Oh,
It was on 24th, but they
Okay.
didn't file.
okay.
I beg to mention item number 3.
20. 23. Oh, 0. Ah,
Well, I have received a copy of additional affidavit filed by the respondent of number 2 on this morning only. So matter may be fixed on 8.
additional affidavit, you have already received the copy.
Yes, this morning only I have received a copy of it
Filed by whom?
by respondent number 2.
By the department.
By the department. You are Mr.
Omodi.
Submitted by Omodi, the land council for the petition that today only he received the additional affidavit filed by the respondent and accordingly needs some more time to prepare the, some more time for, you are you going to file any reply and all? Wait for adjournment to prepare the case. So 18th already we have fixed, it can be 19th?
8.
8. Friday, I do not, I can't say Friday. Actually, 6, 7, and 8, lots of matters are already been fixed. I don't know.
On 14th, if possible on
14 can be, 14th also go. Hmm? 13th or maybe one down. Can be on 14th then, sir. Huh? Huh? 19 will do, 19th, 1-9.
Right.
Mayor, my lordship, I beg to mention item number 18, my lordship. This matter will be lifted after 2 weeks. And for respondent number 8.
It's a hearing matter.
Yes, ma'am.
You are for?
Respondent number 3. BC.
Mr. Topo was also here in this place, I think. You have taken the consent of the other side. With the consent of the other side, and then consent. The state respondent, the government advocate so and so, appearing for the state respondent, wait for an adjournment. After 2 weeks? Prayer allowed list after 2 weeks.
Lordship, I beg to mention item number 4, 7, and 12. I'm for the petitioner.
7 and 12.
4, 7, and 12, Lordship.
Why?
I am for the petitioner. Lordship, conducting counsel, Sunil Mao is out of station. Therefore, Lordship, kindly matter may fix after 1 week.
Have you informed the other side?
Yes, Lordship. Consent has been taken.
I think
4, 7, and
4, 7.
is praying adjournment for 4, 7, and 12.
In
As
4,
for-
I am for state respondent.
in
Four,
which?
item four.
Item 4. Your on to liquidable. The tariff is in 40. Item number 4. G tariff and then 7, Mr. Katu is here, I think, no?
Yes, 7, 4, 7.
You're not in 7?
Yes.
No, I'm not.
We come to same condition will be the counsel for the other side. The counsel for the petitioner appearing on behalf of S-Bound for an adjournment stating that they are conducting counsel is out of session. How many weeks you need?
After 1 week.
Accordingly, matters may be listed after that. 1 week will do. You are also here
Yes,
in
I mean, item number 7, my lord.
item number 7.
My lord, I beg to mention item number 8.
Hmm.
Leading counsel, Mr. Odugung, is out of station, so matter may fix after 3
Leading
weeks.
counsel, Mr.
Odugung,
I can say model first. After 2 weeks,
3 weeks.
Lordship, I would like to mention item number 10 and 11. With consent of court of parties, matter will be taken out for 3 weeks also.
then to there are the respondent side name of the counsel for the respondent reflected in 11. It's a contempt matter, I think. It's a not 11 number to do. 11 distribution. 10 and 11. Have you filed your rejoinder affidavit?
Yes,
Rejoinder affidavit you have filed?
not yet, Lordship.
Not yet.
Yes.
How you sustain so the counsel appearing. You're appearing on behalf of whom?
Petitioner.
Huh?
Petitioner.
Yes, so in.
Yes, Your Honor. For petitioner, Lordship.
You said. Yes. With consent of the other side being and prepare my adjournment, further it is submitted by him that the rejoinder affidavit is not yet filed by the petition side. Is the matter accordingly. After 2 weeks, in
3 weeks, Lordship.
after 3 weeks, along with the contempt case C number 44 of 2020.
Yeah, Lordship.
May I please, Your Honor? I beg to mention item number 9.
Hmm.
I am for the respondent, my lord, 4 and 5. In here, my lord, I am supposed to file affidavit in opposition, ma'am. However, the same is not filed. I will file it by today, ma'am.
Yes, you're for the respondent,
I am for the respondent.
you're for the petitioner.
Yes.
Or Mr. Swain.
Lordship, there is another respondent, respondent number 7, private respondent. Member.
Record to reverse. 9. So you are for paying for private respondent
4 and 5, ma'am.
4 and 5.
Yes, ma'am.
Another 2 private respondents are there, 6 and 7. You are paying for 6
I'm
and
appearing for 7, my lord. Lordship, I am for 6.
6.
Lord. And I filed my affidavit.
You have filed your affidavit. You also.
I will also file. Respondent number 7 need to file. They have entered their appearance since
Yet to file.
2021. Since 21, Lordship.
You are yet to file your affidavit in opposition.
Yes, my lord. I need some time, madam.
Obviously, it is 21 matter.
And respondent, private respondent number has been entering since 2021 itself.
Hmm.
And yet they are not filed. Yeah,
Seeking time and money.
yes. So this, there is a last chance.
Hmm. You are Mr.
M. Doji.
Or Mr. M. Doji, the learning counsel for the petition. No, sorry. You are for the petition.
Yes.
So also for the petition. Also heard. M. Doji for the respond number 4 and 5. No?
Yes, 4 and 5.
4 and 5. You are Mr.
K. Lawrence.
K. Lawrence for number 6. And Mr. So you are for 7.
Yes, ma'am.
Respond number 7. You 1, 2, and 3 are represented by you.
Yes, we have 5 years.
Yeah, so and so. So hard MS so and so be appearing for the state respond number 1, 2, and 3. The respondent number 4, 5, 6, and 7 accordingly paid some more time to file their affidavit in opposition. Post of in that context, Mr. Mr. Arigno submitted that this writ petition is pending since 2021. And respondents have entered into their appearance in the year 2021, but till now, they have not filed their affidavit in opposition. Accordingly, he paid one last chances may be given to the respondents to file their affidavit in opposition if any. Next, considering the submission made by the learning counsel for the petition and also considering the matters on the record, all the private respondent number 4, 5, 6, and 7 are hereby directed to file their affidavit in opposition.
6 already filed. No,
6, sorry,
6,
4, 5 to file their affidavit in opposition on or before the next date of listing, and that may be considered a last chance for on or before directed to file their affidavit on or before. So we are giving time, but this time you file your
Yes,
affidavit in
yes.
opposition within 3 weeks can be given.
Yes, please.
3
I know.
weeks?
Okay.
3 weeks.
Obliged.
May I please, Lordship?
Yes.
Lordship, this is a transfer matter.
Hmm.
The petitioner
He is working as a regular executive engineer at GECO, Upper Siang District, under the Department of Hydropower Development. And the private respondent number 4, he was transferred at the GECO at the same place as a assistant engineer, as a functional, as officiating from engineer during the year 2022. He was working under me. And thereafter, what happened in the present impugn transfer order? I have been transferred, and my junior, who was working as a functional assistant engineer, he has been appointed as a caretaker of me. Lordship, I have annexed the impugn transfer order at page 14. Page 14.
Caretaker means, why caretaker?
Caretaker.
Caretaker.
Yes. And in charge, functional, caretaker, officiating, all these are comes under same meanings. I have annexed, Lordship, my impugn transfer order at page 14. And there was one notification from the government of Arunachal Pradesh, which was duly issued by the Department of Administrative Reforms. I have annexed this at page 16, Lordship. I mean, at page 16 as annexure P2. This is important. Page 16, annexure 2. Serial number 2, Lordship. May I read out this? Serial number 2. Serial number 2. May I read out?
Yes.
The earlier decision of the cabinet dated so and so, read with so and so, dated so and so, and so and so, shall be strictly implemented. That is all officiating, functional appointment, and out of turn basis shall be cancelled with immediate effect, and such lower functionaries shall be reverted back from the higher level post to the original substantive post from which they were posted to higher posts on officiating functional basis without waiting any further order. This was the standing council, standing order. In present case, what happened? The private respondent, his original post is junior engineer, much junior to me. And during the year 2002, I have annexed at page 19. This is the first, for the first time, this order has been violated by the private respondent. At page 19, I have annexed. He has been posted as a functional assistant engineer from junior engineer. And thereafter, the present impugn transfer order, I have annexed at page 14. This is the present impugn transfer order. Now,
where it is a functional?
Page 19, Lordship.
Yes.
Page 19. May I read
What is
out?
a functional?
Yes. Now the present impugn order at page 14. From engineer to now, he has been given the caretaker of the executive engineer. In one district, there is one superintendent engineer who is the higher authority. In one superintendent engineer, the petitioner and another executive engineer, namely called Amma Falo, he is also working under one superintendent engineer. Even if in case I have been transferred to some other place, the executive engineer, Amma Falo, he is the qualified person to take care of this post. But the private respondent, the authority has been just to accommodate, and that has been, this time he has violated twice against the notification, government notification. Lordship, my humble submission, Lordship may kindly interfere. If not, in near future also, the officer, they will demoralize because of the higher authorities, some loopholes. So my humble submission, Lordship, notice may be issued, and till the returnable, that kindly this transfer order may be issued. That's my humble submission.
You have been transferred to monitoring the fish Itanagar. So you are not the executive engineer,
I'm a regular executive engineer.
regular executive.
Yes. The private respondent, his original rank is junior engineer. And he was working transfer during the year 2002 as a assistant engineer, as a functional. Again, not this time also he has been given the charge of caretaker of the executive engineer. For those days, 4 or 5 years back, in here at Arunachal Pradesh, many lower officer has been posted as a official. And for that purpose, the higher officers, their promotion were disturbed. For that purpose, this notification has been issued by the government of Arunachal Pradesh.
Yes, Mr. Tuck. No, we transfer. Yes,
Only one part, Lordship, the statement of the petitioner, Lordship. The private respondent is his substantive post is junior engineer, Lordship. So only that part, Lordship, junior engineer, how junior engineer can be, Lordship, given the charge of.
no, he was functional assistant engineer.
He's a functional assistant engineer, but his
Yeah.
substantive post is junior engineer, Lordship. He's only functioning as a AE, otherwise he's JE. This is a case. Anyway, request maybe I'll produce a request on Wednesday, Lordship, on 13th.
Didn't I have some personal problem? 13 may not be possible.
Thursday, any date, next week, any date. Otherwise, attempt can be made on Monday also.
We're not passing any order on stay, etc. Monday you produce the records.
No, that Lordship may see last.
Lordship, otherwise, because already it's left only 6 days, we are going to transfer me. At least till the record
6
call.
days means 6 days means.
Till the record call, at least the status quo may be done. At least status quo, even not stay also, status quo. That's my humble submission. Yes, at least
You're
status quo.
challenging the transfer order, this one transfer. Basically, because it is hampering you only because he is the in charge.
Yes, in just and by violating the notification, which is standing order. And that is also for the
But
2 times.
in your earlier place of posting, since when you were there, otherwise you don't have any objection.
No.
In regarding transfer.
Yes, if the same rank could have been transferred, I have no, because I have also my own respect. At least till the record call, at least status comment.
Lordship, why I'm
What
not
interest?
seriously objecting, because no one has been brought in his place. So that's because this the private respondent, he's already working there as a functional AE, Lordship, in that. On Monday, Lordship, I'll produce a request. Otherwise, the petitioner of his own, Lordship, he don't have any case. Because he has been transferred, who is coming there or not, that's
He's
not his concern.
He's not concerned. That's what I'm saying. It's not his concern. Yes,
Yes.
obviously.
Yes.
Yes, this is violating the notification and that is hampering you as because junior to you is been in charge of this.
Yes.
That is
That is indirectly insulting me.
Otherwise,
It's
you
not-
have-
That is indirectly insulting to me, my service.
I'm only concerned with this notification because
So my
we
humble
have to
central
be-
lordship,
we have to be in conformity with our own notification.
till the time at least status quo.
I heard Mr. J. Giatinigi. Suspense for the council for the petition. Also heard Mr. S. Tapping, the senior government advocate for the state respondent, appearing on behalf of state respondent number. Otherwise, you are appealing for 1, 2, and 3?
I'm for 1 to 3. 1,
1 to 3.
1 to 3. All the children.
This is an application under Article 226 of the Constitution of India, challenging the legality and validity of the transfer and posting order number SHPD -11014/13 of the 2021 dated 30/10/2024. 24. That's right. Next para issue notice. So and so. No formal notice is required to be issued on 1, 2, and 3. However, the copy of the petition be furnished to the respondent number 123 during the course of the next one. It is submitted by Mr. Yati, the learned counsel for the petitioner further that the transfer order has been made by violating the notification dated 01/07/2022, where it is by the and violating the violating the notification, especially the term, especially the clause 2 bracket Romans. It also submitted that the private respondent number 2 was working as a junior engineer and he was posted as a assistant engineer functional. However, by violating the notification dated 1/07/2022 issued by Department of Administrative Reforms, Civil Secretariat, Government of Arunachal Pradesh. Accordingly, it is submitted that till the returnable date, the transfer order dated 28/10/2024 may be stayed. Next one, Mr. Tapin, the learned senior government advocate, submitted in this regard that on the next day of listing, he will produce all the government records. However, he submitted that however, he raised no objection in stay of the transfer order till next date of listing, as it is claimed by the petition that the transfer order has violated the notification of the government dated 01/07/2022. Monday to बहुत है, Friday Monday बहुत है, possible now. Tuesday कोई तो नहीं ना, Tuesday कोई बोले. Monday, lots of matters are there and fixed. In fact, Tuesday can be.
Any date, no issue. Any date. Next week, any date.
Because I'm going to give a stay order too. That's why I'm saying
Okay, Tuesday.
then.
Tuesday.
My rest. That's good, at least. I'm not.
No, I'm going, yeah, stay. Your order has been stayed.
Obliged.
Stay would be more perfect.
Yes,
Obliged.
stay will be more perfect. However, what status quo will maintain our till returnable date. And you take state for the private response.
Obliged.
All right.
Tuesday is good. Yes.
My lord, this petition has been filed. My lord, agreed by non-payment land compensation by the Indian Army. My lord. They have entered into my premises private land, making promise that they will acquire the land and make fair compensation. My lord. Believing their request consented, they have entered into my private land and constructed the road to the extent of 10 kilometers. And to that extent, even they have written to the district administration, they are saying that we are acquiring the land. And despite of that, although they have illegally constructed 10 kilometers of my private land, but they have not paid and never even not initiated the process for acquiring, nor paid the compensation. Therefore, there was round and round of the sitting was also there. Several sitting was also there in coordination with the district administration and the Indian Army official. They were also commandant also present, and they even the meeting they have consented that will be paying clearing, but till now they have not paid. So this
land acquisition process is also not initiated.
Not initiated. Initially, Maludusi at page 34. This was their first, the letter written to the district administration expressing their intention to acquire the land at page 34. But to tell my lord, even before this letter, they have already entered into my premises, constructed the road, man. Page 34, my lord. This is letter written to Deputy Commissioner, my lord, by the commanding officer, 2 my lord, 23 grenade, my lord, grenade. By this letter, they have expressed their intention, the contemplating to construct, although they have already started in my premises, they have said the contemplating to construct this road, my lord. And for that purpose, serial number 2, they requested the district administration to provide the details of landowner to facilitate to initiation of acquisition of land. But thereafter, nothing has been happened. And again, my lord, detailed process was initiated. Even this forest clearance has also been issued by the concerned department for acquisition. Subsequent, I have annexed it. And now, just relevant part next is the forest clearance at page 36, my lord, for acquisition purpose. Forest clearance has also been done. Although they have constructed, now page 37. Page 37 is also same letter with like that of the first 34 page, my lord, saying contemplating, although they have started this, but using the contemplating, although they have started. Now the page para 2, my lord. The sought clearance from the district administration for compensation. Without even assessment, they sought for, although we have not, what we are concerned is we should be given our adequate, our fair compensation only. But despite that, without doing this, nothing, and no compensation, no initiation has been done. Now, page 38, my lord, see the construction there, how they have done. 10 kilometers area of the land has been 10-kilometer area, my lord, it includes other also, but my area falls under this, the street kilometer already constructed. Page 38 to 40 is I have annexed the photograph, my lord. So when, despite of the having constructed this illegally constructed without acquiring the land, that we made a complaint to the additional deputy commissioner at page 47. That we made a complaint, we requested authority that this all should be illegal things should be, activity should be stopped. Initially, they made the request, making promise that we are acquiring land, but nothing, any acquisition, no compensation paid. And top of that, they have constructed 10-kilometer road along the my land, man. Then thereafter, my lord, at page, my lord, see page 45. Page 45, it's my the sketchment of land, my lord, showing the alignment of road constructed by the Indian Army. 2 plot I have, my lord. This first plot is measuring 29,000 at page 45. Middle of the my plot of land, my lord. The road from Pangin to Georging, my lord, that has been constructed, bisecting my landed property. Second is, my lord, next plot is also, it also passes through. Page 46, they've already constructed. And they're duly acknowledged by the district administration, so they're duly verified. Now, when their formal acquisition was not done, no payment was made, then we made a several complaints. And accordingly, pursuant to our complaint, the meeting was convened by the district administration at page 47, Maluchi, the minute of meeting. Meeting was held on 31st May 2022. And not, it was meeting, minute meeting notified on 22 June, my lord, at 2022. But after trade discussion, decision at second para, my lord, that issue raised is the second para, the third para, my lord. After trade discussion, the House unanimously resolved to take action as under. In the issue matter, it was raised, even the no intimation was given to district administration, although it should be the foremost act duty of the authority that we require, let this land be acquired through this. At least this is the prerequisite condition, but that has not been done. That is reflected in the minute itself. Now, after discussion, the trade discussion, what regulation they have adopted. Number one, Indian Army, they have requested you please stop the further construction, and they have also consented. And whatever construction you have done, first pay the compensation. They have consented in the meeting, they were present, but now nothing has been done, man. So again, series of representation were filed right from 48 to 53, 42, my lord. Nothing has been done. So this was agreed by this, although it is admitted fact. Now subsequently they're saying that instead of acquiring in whole, they said whatever construction we have made, and they, when we entered into our premises, will pay rental basis. We are acquiring, we are taking our land right from the since when we entered into a premises from 1st July 2020 until that, whatever the construction, whatever damage we will pay it on higher basis. Subsequently, the second proposal, they have making departure from the earlier their agreement. They have made aspect of, we have protested that this cannot be, you have cheated us. Because on the promise made by that, you're acquiring a land, you have entered, but now you are making departure from the earlier stand, earlier commitment. Even in that case, or be that as it may be, even the no higher compensation, higher the charges, the rental pay has also been paid, even assuming that what proposal they have made. Madam, this is the situation, madam. That's why, madam, I have been agreed by their arbitrary action, madam. I filed this writ petition, madam, praying for direction upon the concerned authority to acquire the land in accordance with and pay compensation as per provision law.
My lord, main is the Union of India to ensure, my lord. Anyway, my lord, I'm representing respondent number 4 and 456, my lord. Now, my lord,
Notice maybe.
my lord, one thing, my lord, is better to clarify. My lord, so far, my acquisition is concerned by the central government, especially for the army people. There is a designated officer is called Defense State Officer, my lord.
Defense state office.
State officers, my lord. It is his duty to, my lord, process and acquire the land for the Union of India, my lord. And here is the case, my lord, some captain, major, my lord. This is just a, what you call, internal communication only to the district administration. Now, we don't know exactly the intention of the Union of India, my lord, whether they actually want to acquire the land or not, because this is only for operational purpose only, not for any other purpose, my lord.
But whatever, suppose.
But whatever,
Also,
yes,
if someone acquires the land and through his land, in fact, the road has already been constructed for 10 to 10 kilometers.
yes, my lord.
So-
Then, my lord, they have to pay something. Yes,
Then has-
understood, understood. Now, my lord, now this operation period was, my lord, 2020 to 2022. Now we're in 2024, my lord. That period already lapsed, my lord.
That is why I approached this call, madam. There's no
My lord. So for hiring charge and all these things, maybe, my lord, they are right, my lord. So at this stage, you also may issue notice, my lord, let this Union of India come up with the affiliate, my lord, what exactly they want to do, my lord.
So you're representing one,
Respond number 4, 5, and 6, my lord.
4, 5, 6.
I am referring to respondent number 3, madam.
Yes. You are land management.
Yes, madam. Yes,
Managing
madam, our role will only come when the defense state officer, he send a letter to the deputy commissioner seeking that we want this
But that
land.
has not been done.
That
That
has
is
not
the main
been done.
issue.
Yes, that
There
is what
is no initiation of process of the acquiring, there
Yes.
is no formal, things were there.
I mean, this is my lord.
Yes,
This,
Mr. You are
as of
appealing
now,
for-
we do not have any role, madam.
For respondent number 1 and 2.
1 and 2. Okay. Are these suspense of credible? 3, 4, and 5. Take a paper question. No, 4, 5, 4, 5, and 6. And 3, Mr. Kamdu. And for 1, M. Carter for 1 and 2. Because বাকি issue notice করে দিব, this is an application for it. Issue notice so. Mr. Yes. No. The person who is paying for pregnancy. Additionally, also has submitted that the defense state officer is the proper person who used to verify all these records records and all, but till now there's no information as to why there was any formal process was initiated by the Union of India or the Department of accordingly, it is submitted by all the respondents. The councils appearing for the respondent, they needs, you need 2-3 weeks time or you want to raise any documents or you want to file your affidavit?
My lord will come up with the affidavit. Actually,
Affidavit.
basically it is the central government, my lord, who has to give the answers, my lord, whether they want to acquire the land or they want to pay the, my lord, higher charges, my lord. My brother is here, my lord.
Kato will explain, yes.
For which time may be granted, my lord, I take instruction from the department.
As you were waiting for last since two
Yes,
years.
my lord. Since 2020, my lord.
2020.
It's been 4 years, my lord.
What will affect you for 4 weeks?
My lord, that's in that case, my lord, there's a provision in our Land Acquisition Act 2020 that even the interest is stipulated 15%
We'll see all
interest,
this,
my lord.
because it's a I mean, prima facie, it is in that you should pay something at least.
Yes,
Where your land has been acquired for whatever purpose.
My lord.
So 4 weeks time you have given
Right.
to file your affidavit.
Deeply obliged.
May I please? Lord?
Yes.
My lord, here in this case, I was appointed as a coordinator under the Sarva Shiksha Abhijan scheme in the year 2005. So as on today, I am serving in the department 19 years as a contractual basis. So my appointment order is, my lord, is page 19. So type copy is page 20. I was appointed on the contractual basis, and this appointment was based on the interview conducted by the board consisting of the Deputy Commissioner of Kurungkome District, the then Kurungkome District. It was normal procedure was followed. Then, in the meantime, under this scheme, thousands of teachers were appointed. Subsequently, government has framed a policy that 80% of the teacher will be absorbed, regularized, base-wise, on the basis of seniority. And they have been regularizing wage-wise. But in case of this ministerial staffs, non-teaching staff, they have been left out. But sometime in the year 2000, they also proposed to regularize the non-teaching staff also, but this could not be materialized as you. So my dear, my lord, in this case, although I have no right as to claim regularization, but when my entire prime life has been spent serving the state, and if there is no post, why I should be used till now? Now, in other district, many of the district coordinators, various coordinators are there. They are being used by taking the their service is used by who are serving as postgraduate trained teachers. They are being used as a coordinators. But I'm also qualified to become a teacher. I'm MA B.Ed, my qualification is, and I have undergone several training during the course of my service. So, my lord, this case, I have a limited grounds, but then the state
mighty state, welfare state, they cannot keep their employees, using the employees indefinite periods. Even there is no single break there. Once it was appointed in the 2005, till that there is no any order that my service was break. Without any break, I have been serving since 2005.
Have you made any representation before the authority?
Yes, we have submitted several representation. They said that we'll consider, but there no any action. So in case of I am referring the Uma Devi, although entire case is against us, but paragraph 53, it says that when this government has used the employees who has been appointed irregularly, not illegally. But in my case, even it cannot say that it was irregular. Duly board was constituted, interview was conducted. On the basis of interview, I was appointed. Only the problem is that it was from the scheme, that is Sarva Shiksha Abhijan. Now it has been subsumed into integrated something. No. Now this scheme is name is changed, but same employees, same staffs are used. Now all the person who were appointed under the scheme as teachers, they are regularized batch wise, and they are continually regularizing. So lefting out the non-teaching staffs, ministerial staffs, it's create a hostile discrimination against these employees. So my humble submission is that government may be directed at par with the teaching staffs. The non-teaching staff may also regularize on batch wise and on the basis of seniorities, at par with their policies. So,
My lord, just make submission, my lord, the intimation, my lord. This here, my lord, I filed the affidavit, my lord. So, if petitioner want to file rejoinder, my lord, it can be. Well, till now, the rejoinder has not filed, my lord. In that case, my lord, we have specifically taken our stand that the policy decision does not cover the petitioner's case, my lord. The policy decision was in respect of teaching. So
he is also admitting the fact that the policy decision is
My lord.
but the question is that you have utilized his
Yes.
service for last time.
Yes, my lord. That part, my lord, may I pray, my lord,
Can there
if they are
be
not
any-
filing rejoinder, my lord, can this be fixed for a hearing, noting that the pleading completed, my lord? If want to file rejoinder, they can also file, but I thought that they may file the rejoinder. That's why, my lord.
You are not so prepared.
So if it is not, if they are not going to file, we can fix for hearing. In that case, my lord, I'll also make submission on on part of the department why the regulation cannot be done. There's no discrimination as such. So for Uma Devi's concern, Uma Devi's case is concerned, it is in case if in the not in a particular scheme or if the department are using on
Yes, that is it.
in their own department in the state in own capacity. But here in the case, the appointment has been made against the scheme of the central government, and central government, we don't know when this scheme will be terminated. So having conscious mind of all these things, person join in service and they are on regulation, and if among them, basing on the criteria of the and the responsibility of the employees, if certain class of the employees is regularized and certain is left out, whether such action is amount to arbitration, whether to discrimination or not, in that aspect also I'll make a submission and try to make distinguish on the Uma Devi's case, my lord.
Yes, obviously.
That part, my lord, in that case, my lord, this may be fixed for his hearing.
Actually, he is not ready for hearing today. You are going to file any affidavit in reply?
my lord, in my
If
case,
not, then we may fix it
For hearing.
shortly.
in fact, I have not said that this policy cover my case. Reason is that they have frame a policy. The person who has been taken from the same scheme, Sarva Shiksha Abhijan. So we are also from same salaries, also from same head. So one set of employees, they are regularized as per policy on batch wise or as per seniority. So one set of employees are left out.
But apart from regularization, was there any examination was held for direct recruitment and all? Why did
No.
you appear?
No. In case of, there is no such examination.
Like what I'm just saying, this is not judicial department and all.
Hmm.
If you are serving for a contractual basis for say last 19-20 years. So what we do that in direct recruitment process, if we release it, that there may be given a priority. Priority in effect as their work experience. For that in reason they may be absorbed.
Yes.
But in your case, you're purely a contextual basis and I think.
My lord, even in RD department, DRDA. So DRDA, the employees of the DRDA is, DRDA employees. They are, in tier scheme is under Government of India scheme.
Yes, yes, obviously.
But it is duty of the state government to frame guidelines to absorb them in line with the, absorb them in state government. Now this Sarva Shiksha teacher.
Then Mr. Tagum, if better maybe
Fixed for hearing.
is for hearing, then we are going to file any.
Yes,
affidavit?
if
No. He is saying that are you going to file any affidavit in reply because his office.
rejoinder.
Rejoinder.
Sorry,
Reply.
rejoinder.
Yes, I am good.
You are going to file a
Yes.
rejoinder. So how many 1 week, 2 week, whatever.
2 weeks, within 2 weeks I will file.
Minimum 2 weeks. Then it can be heard finally.
My lord.
Because he has taken some pleas in these counter affidavit.
Okay.
Affidavit is very hard, Mr. G. Tara, the counsel for the petition, and also heard Mr. G. Tagum, the learned counsel, appearing for, you for respondent number?
My lord, I'm for respondent number 1, 2, 3, and 5. 1, 2,
1, 2, 3, and
3,
5.
and 5.
For your appearing? So, yeah, Ram, the learned government advocate, appearing for respondent number 4. As per office note dated 5/11/2024, affidavit in reply or rejoinder affidavit is not yet been filed by the petitioner. However, Mr. Tarak submitted that they're going to file their rejoinder affidavit and accordingly paid 2 weeks time for the same. Placed a matter after 2 weeks, enabling the petitioner side to file their affidavit, rejoinder affidavit, and matter may be finally heard and disposed of in the next week.
Deeply.
Number 6.
Yeah, my lord. My lord. My lord.
Yes,
I
yes.
prefer 6, my lord. This is also a compensation matter, my lord. Here the writ petitioners my lord, are from 28 villages, my lord. 28 villages, my lord. They are 28 villages, my lord. Now, petition number 1 to 8 are the Gauburas of these 28 villages, my lord. Now they belong to Sharshaw community, my lord.
Yes.
So what happened, my lord? This respondent, my lord, Indian Army, my lord, is in occupation of land at Kula, Y Junction, Klemta, Khemker, Assam Hill, Bakritop, Bomla at Tawang district, my lord. Now, since 1960 and 1980, they are in occupation of our community land, my lord. But they have not acquired our land, my lord. So why, my lord, we have filed this petition. Now, what happened, my lord? We have submitted several representations before the Deputy Commissioner. Page 131, my lord, on 6/7/2021, my lord. Again, we have wrote application to representation to the Honorable Chief Minister, my lord. On 27/7/2021, my lord. Now, what happened, my lord? There was a coordination meeting. Page 136, my lord. Between the Union of India, my lord, consisting of my lord, defense estate officer and other army official. Page 136, my lord. 136, my lord. Serial number 2, my lord. The DO informed that he has been instructed to carry out DGPS survey of all army assets in Tawang district, and the same needs to be completed within September, my lord. So we were assured that our land would be acquired, my lord. So no process was initiated, my lord. Again, we started
submitting representation before the deputy commissioner. That would be page 138. There are several representations. Page 138, page 140, my lord. Page 1. Now, my lord, page 145 now. In page 145 also, my lord, the page 145. Second last, 145, my lord. Second last line, yes, madam. On once verification of survey map compilation of field data are done, then survey of remaining pockets may be resumed, my lord. But what happened in another aspect, my lord, there was another dispute, my lord, over the land at Chujejiji, Tawang, my lord. Now, regarding that area of land, my lord, the verification was conducted, my lord. Now, by this communication, my lord, they have assured that the other pockets of the land would also be assessed, my lord. No, nothing had happened, my lord. Then, my lord, we have also submitted representation, my lord. Again on 24/2023. My lord, before that, my lord, what happened, my lord? In another pockets, my lord. In some other cases, my lord, the land were acquired, my lord. Page 153, my lord. At LGG, my lord. Now, what we are saying that they have selectively, my lord, acquired land, my lord, land acquisition, my lord. Now, page 153, my lord, with respect to other land, my lord, they have acquired, but our land, my lord, since 1960 and 1980, they are in occupation of land, but they have not done anything, my lord, for acquiring the land. So we finally have submitted representation on 24/2023, my lord, page 156, my lord. Requesting the authorities, my lord, either to acquire the land or vacate the land, my lord. Now, what happened, my lord? The Indian Army, my lord, affidavit, my lord, may please come to affidavit of respondent number 10, 11, 12, my lord.
Yes, please.
Affidavit of respondent number 10, 11, 12, my lord.
Ten, 11, 12.
Yes. Yes, my lord. Now, your lordship, they are the Indian Army, my lord. They are in occupation of our land. Now, my lord, may please come to page 11, my lord, of their affidavit, my lord. Now, my lord, what is the state of the, my lord, they are ready to acquire our land, my lord. They are ready to acquire. My lord, please come to page 11, my lord. My lord, may please come to C, my lord. This is para 6C, my lord. 6C. May I read, my lord? The actions are at hand to take stock of all land under jurisdiction of station headquarters Tawang towards its regularization in terms of acquisition, hiring, and dehiring. The Session Committee representative, instead of arriving at an amicable solution to the land issue in consultation with the army, are preparing to take a legal recourse for the reasons best known to them. When they are accepting, my lord, to acquire the land, my lord. So I pray, my lord, this matter may be disposed of. This writ petition may be disposed of, directing the respondent authorities to initiate land acquisition process, my lord, within a period of 3 months. That is my prayer.
Yes.
Yes, my lord.
Yes, my lord. As per the affidavit filed by the newly implemented respondent number 10, 11, and 12, my lord. Earlier, they were not the necessary made as party, my lord. After subsequent implemented, the implement of the respondent number 10, 11, 12, they filed affidavit, my lord, as rightly pointed out. By this affidavit, my lord, the army, Indian army is ready to acquire the land, provided that, my lord, the other necessity and everything seems to be provided by the, my lord, district administration. So therefore, at this stage, my lord, the matter may be disposed of with a directions to the deputy commissioners to carry out the, my lord, the joint survey as required, and my lord, the procedure in accordance with law. And regarding, my lord, the two affidavit has been filed. One is defense estate officer. The extent of the defense estate officer is contrary to the stance of the, my lord, the Indian Army. My lord. Of course, it is within the, my lord, the department, within the army. But in principle, approval is required. My lord, that requirement will be initiated by the Indian Army or the defense estate officer. However, my lord, the first
No, what is the process? In fact, they are ready to acquire the
My
land.
lord.
By you are saying that
As per the
their main
affidavit, as per
authority is
this
the state
affidavit.
defense officer.
Yes, madam.
But
As per
they see,
as
the deputy commissioner has to assess the land and all.
Yes, madam. There has to be participation
Madam,
from
first
all
of
the
all,
parties.
decision whether they wanted to acquire the land. By this affidavit, they are clear that they wanted to acquire the land. Number one, my lord. Number two, my lord, even if it is my lord, the willingness and other things has to be followed. Therefore, my lord, submission is, if the Indian Army is ready to acquire the land in accordance with law, my lord, that may the direction may be.
My lord, there is a procedure, my lord. Before acquisition, the prerequisite is that, my lord, the user agency matters. They should send a request letter for acquisition to the deputy commissioner. If that is not, my lord, in some cases, my lord, there was an instance, my lord. My learned friend here has argued in those cases, my lord. Before the principal approval from the Ministry of Command, this then allotment process cannot be initiated. There are some, in some cases, my learned friend has argued in that line, man. So if the principal approval from the ministry is obtained, my lord, then only requisition letter will be sent to the deputy commissioner, my lord, by the user agency, my lord. All these prerequisite this exercise to be done, my lord, before the issuance of the notification. Then only, my lord, we can go for this issuance of notification for this acquisition.
No, my lord, stages is that, my lord, your lordship would direct that respondent authorities to initiate land acquisition process. Now they will initiate land acquisition process. Now, what about the Indian Army?
Most probably the approval is required from the.
Yes, my lord.
No, my lord.
Therefore, my lord, my submission is that, my lord, if my lord is disposing of a matter, my lord, direction may be particularly issued to the army authority, my lord. Union of India, my lord.
Yes.
To send requisition letter to the appropriate authority, my lord. If that is done, my lord, from our part, my lord, there will be no difficulty, my lord.
My lord, it is between the, my lord, the problem is between the Indian Army and the, my lord, the defense estate officer, man. The one hand, they are saying that in principle approval has to be obtained. Then, my lord, Indian Army is in a position to, my lord, acquire the land. So that direction, my lord, has to be taken. The joint decision has to be taken by the DO as well as the, my lord, the Indian Army, man. That is, of course, official procedure. Therefore, my lord, what I'm, my lord, submitting is, if at all, my lord, is to be acquired this piece of land in accordance with law, it has to be acquired in accordance with law.
Yes.
Therefore, my lord, it will come whether in principle of approval is required, whether in the willingness certificates will be given or not. The requisition, everything's, my lord, it comes under the in accordance with law. So therefore, if in principal approval is not given by the, my lord, the ministry, Raksha Mantri, my lord, then the army has to vacate. Then army, when the army is in actual positions of the land, they wanted to acquire the land. But the difficulty is, my lord, I'm fairly submitting before this honorable court. How, my lord, this will be addressed by the honorable court? This is completely internal matter between the army authorities as well as the.
Definitely, will pass the order in accordance with law and
Yes,
after necessary
Yes,
approval from the department
If
authority concerned,
principal-
that will be there. Otherwise,
If principal approval is not given by the Raksha Mantri, my lord, then army has to be vacated. Then army, if at all ready to acquire, in principle approval has to be given, my lord. Therefore, my lord, I have pointed out, affidavit filed by the respondent number 1 and 2, my lord, they are saying that in principle of approval has not been given. So therefore, acquisition process cannot be, my lord, initiated. Now, army authority, respondent number 10 and 10, 11 and 12,
They are
come with
ready to
affidavit. Yes, we are ready to acquire. Joint survey may be carried out. that malad aspects they have filed affidavit. So therefore, this is always happening between the malad in some cases, right? My malad friend, that malad acquisition regarding that in principle approval. There was so many malad debate before this honorable call that in principle when in principle of approval is not given, how acquisition process can be initiated now. So therefore,
That means that's what, unless and until the principal approval is received from the Raksha Mantri and all,
Raksha Mantri.
neither the army nor the DC can initiate the process. That should be the one-way hamper. Otherwise,
Yes,
No, my lord, what I'm submitting is, in principle of approval, whether this piece of land is to be acquired or not, it is within the army authorities, my lord, within the ministry, my lord, defense ministry, my lord. Minister, Raksha Mantri has to give it for in principle approval. Then, my lord, the DO will initiate the process for the acquisition of land, my lord. Now, my lord, they are, my lord, in contrary, army has already possessed the land, my lord, occupied the land, rightly.
yes.
Yes,
That's why they are not opposing it, that they are
Yes.
ready to acquire the land.
Now the army, they are saying that yes, we are ready to acquire the land. Now the Indian, the defense estate officer and the Raksha Mantri is by filing this affidavit, they are saying that
Their respondent number?
respondent number 1 and 2, madam.
Achha.
Respondent number 1 and 2, madam. Therefore, madam, my friend is madam, that may be also madam, one madam, the paragraph may be added that this internet, whether in principle of if really wanted to acquire, in principle of approval is to be madam, sorted out within the madam, the ministry. Madam. By paragraph 4, madam, may
Paragraph
just
4.
affidavit filed by the respondent number 1, 3,
1 and 2.
5, madam.
135.
135, yes. Paragraph?
Yes, madam. Para 4, madam. Page number 3. Time and again, madam, these situations has come up before this honorable court in case of malad acquisition, madam. Now, the malad, by this malad affidavit, they are saying that in principle approval is required by the married malad. As per the direction and the guidelines time to time issued by the Government of India, Ministry of Defense, whenever requirement of any land on permanent basis is arising for Indian Army for a particular purpose, the in principle approval of the Ministry of Defense is obtained first. The in principle approval is the approval of the necessity of land projected by the by user services. That is Indian the Army, Navy, Air Force, etc. for a particular purpose or the projects for which the case is initiated by the concerned user services. Once the necessity is approved, that is in principle approval by the Ministry of Defense, the case is processed for obtaining the permit. So, my lord, what I'm pointing is, one hand, the other respondents are saying that in principle approval for initiations of the acquisition has to be obtained first. Now, the other hand, the Indian Army, they are already in occupation of them. So therefore, this in principle of approval and whether this piece of land is to be acquired by the Indian Army or not, that past steps may be sorted out. Thereafter, to that effect, direction may be given. And thereafter, if at all is to be acquired, land may be acquired in accordance with law.
My lord, I have one experience, my lord, in compensation matter. My lord, what happened in my case, my lord? The direction was passed by this honorable by Justice Aisa Indasa by directing the respondent authorities, my lord, Indian Army to either acquire the land or vacate the land. Now, what happened? What did my lord, Indian Army and Defense Services Officer and the district administration? They initiated, my lord, they first made the joint verification of the area. Now, after verification of area, the land required by the Indian Army that has been ascertained. Now, after ascertaining that area of land, they have sent it to the Ministry of Defense for in principle approval. Thereafter comes the in principle. After in principle approval has been given, then they start the land acquisition process. That is the stages.
Exactly, that is the
Yes,
point.
that- Okay, we'll dispose of
My
it.
lord,
Deeply obliged.
deeply obliged.
Okay, dispose of it.
May I please your lordship? Lordship, I have received the copy of written statement filed by the respondent number 1.
We have already filed.
Yes, we have already filed.
And lordship, as I have submitted earlier, lordship, on the last occasion, service.
Respondent number 2, I think, 1. You are respondent number?
One. Return candidate.
Lordship, as I have
Service
submitted
against
on
who is
the,
also,
service was completed on first of August, lordship. Now, since nobody has appeared on their behalf, so may I pray that ex parte, it may be proceeded ex parte against the respondent.
returning officer.
In other matters, they have already filed their affidavit. I mean, written statement.
Respondent, returning officer made as pro forma respondent.
Yes.
Huh?
Pro forma respondent.
Who? 2 is.
Two.
Returning officer.
Here 2 is pro forma.
Yes.
So there.
It's okay.
So next, that may be fixed for issues and documentation.
You are going to file any draft issues in this regard or?
Yes,
directly
lordship,
friendly? You are going to file draft issues?
and documentation, lordship. Next
Yes,
page.
yes.
No, in the meantime, we will file IA challenging the mentality of this election petition.
In that case, we have to frame the preliminary issue
Yes.
on maintainability.
Yes.
So you raise the ground of maintainability. So that has to be.
No, we'll file separate application.
Lordship, that is up to them, but however,
Why separate application? You have not made any statement in your written statement here.
yes,
Because that can be done now,
Yes.
say in the civil procedure or whatever.
yes.
You can make a statement very well, statement is not maintainable. On the what ground it's not maintainable, write a para in the written statement itself. That can be taken as a preliminary issue or can be decided. Or if you want to file a separate petition, it is up to you. But there is time limit is there, so we have to.
So
We'll file shortly.
So it's up to them, lordship. However, as per the
we are
procedure
fixing it for
for
filing of the
draft issue and documentation.
And in the meantime, you can, if you want, you can file.
Right.
And if, while filing the draft issues or issues, that preliminary issues may be filed. And we may hear it.
There is no whisper in the written statement.
That should be.
No,
But
it's
earlier also.
Just
Generally in CPC, these things are followed.
yes.
We are following the principles of CPC in fact. So CPC is there. Anyway,
Next, no.
heard Mr. Itatal, the learning council for the petition. And also heard Mr. You are Mr. Huh? So, for the respondent number 1. The respondent number 1 has also filed his written statement, a copy. However, the respondent number 2 not yet appeared, though the notice has already been served upon him in the statement. Accordingly, it will proceed ex parte against the respondent number 2. Yes, when it can be listed.
Lordship, can it be on 5th? Because 5th of December, Lordship.
5th of December.
For because Lordship, we have to I have to collect certain documents from the concerned office. Some of the documents which are at the disposal of the concerned authority.
I'll just remind one thing. I will just want to say, because they are raising the point of maintainability, issue of maintainability. So even if draft issues or documents have been faced, they may file the this application for regarding the maintainability. That may be a preliminary issue may be framed and matter may be heard on preliminary issue also regarding the maintenance.
Lordship.
So unless and until the points or grounds they have taken you, okay then, anyway, we will see. Her later matter be listed 5th of December.
5th of
5th of December for filing of draft issues and the
documentation.
by the petitioner as well as the respondents. However, Mr. Spencer, the learned counsel for the respondent also submitted that they will file a separate interlocutory application for raising the issue of maintainability. The respondent number 1 is at liberty to file his interlocutory application for preliminary for the issue raising the issue of maintainability. List the matter accordingly. Thanks.
Deeply obliged.
Good.
Your Lordship, till that we have not been furnished with the extra copies. Yes, Your Lordship.
Why? You have not furnished the extra copies?
On
They
last,
already appeared.
yes.
I'll serve today, Your Worship.
But why? The order was
Yes, Your Lordship.
passed on 7/6 in fact, for filing the copies. And thereafter, under order was on
38, Your Lordship.
38.
They were asked again to furnish us extra copies, but till date they have not.
You have not been also served.
I'm for the private respondent.
No, you have received the copy.
Yes.
Okay. Yeah, after receiving the copy, have you filed your affidavit in opposition?
Need
also?
some time.
So you are 1, 2, 3,
1 to 4, Your Lordship.
1, 2, 3, and 4.
Yes,
5, you
Your
have 5.
Yes.
Heard Mr. Spencer, the learned counsel for the petition. And also heard Mr. Vaigiram, the government advocate for appearing for respondent number 1, 2, 3, and 4. And it is submitted by him that till date the requisite copy of the petition is not being served upon the respondents. Accordingly, the counsel for the petitioner is hereby directed to furnish the requisite copy of the petition. Today itself, you
Yes,
can,
yes.
during the course of the day today. Further, Mr. Pichan, the learned counsel appearing for the respondent number 5, also prayed some more time to file their affidavit in opposition. List the matter accordingly. How many weeks you need if you
4
if
weeks.
you
Your
want to
Lordship.
file 4 weeks?
Yes, Your Lordship.
List the matter accordingly after 4 weeks. You're facing it after 4 weeks. Serve the copy by today itself.
Obliged.
एक नीचे जो है जमा that particular dispose of matter, I'll give it.